You wake up on your wedding day. The dress costs more than your father earns in 6 months. In a leather pouch beneath your skirts, you carry coins your savings. Your work? Proof you exist in this world as someone who builds and earns and chooses. The priest lifts his hand. Your husband places a ring on your finger. And in that single breath, you die. Not your body, your name, your voice. Every contract you signed, erased. Every coin you saved, no longer yours. You are still breathing, still standing in that church. But the law no longer sees you. You are covered. Hidden. Property. Before we go any further, I'd love to know where you're watching this from. Drop your country in the comments. It still amazes me that a story buried in 16th century English courtrooms can reach people on every continent. Centuries later, all right, let's continue. This was England under Henry VIII, but it wasn't his invention. The law that erased married women coverture had been embedded in the legal code for nearly 500 years before Anne Boleyn ever set foot in court. It came from Norman French custom, imported after the conquest of 1066, and it rested on one elegant, brutal principle. Husband and wife are one person under the law. And that one person is the husband. By the time Henry began his reign in 1509, coverture wasn't a cruelty, was simply how the world worked. And when he broke with Rome in the 1530s, when he dissolved the monasteries and executed queens, he wasn't just reshaping religion or politics. He was tightening the machinery of a system that had already made half the population legally invisible. This is the story of that machinery. Not just the queens who were beheaded, but the tens of thousands of ordinary women who were erased every single day by marriage, by law, by a world that measured their worth in dowries and sons. What you're about to hear doesn't come from legend. It comes from Tudor court records, marriage contracts, wills, and petitions for mercy that were filed and ignored. The voices in those documents weren't asking for revolution. They were asking to exist. Let's return to that church in Yorkshire, 1535. You are 19. Your father is a wool merchant, and you've been learning the trade since you were tall enough to reach the account books. You know fleece quality by touch. You know which shepherds are honest and which ones watered down their weights. You've negotiated contracts in market squares while your father watched, nodding. For 4 years, you've earned wages. Small amounts, but yours. You saved them in that leather pouch. You wore them like proof. The feast after the ceremony is lavish. Your dowry £200, a fortune paid for much of it. Guests drink and laugh. Your husband's family toasts your union. But you're quiet because somewhere between the vows and the ale, you've begun to understand. The money you saved, gone, not stolen, transferred. It belongs to your husband now. The coins, the gown, the dowry your father handed over. Even the wages you'll earn tomorrow if you sell wool at market hall of it, legally his. You cannot sign a contract. If you try, it's void. You cannot sue someone who cheats you because you are not a person who can be cheated. If someone strikes you, slanders you, ruins your reputation, your husband must take them to court. You have no legal voice. This is coverture. The old French legal term meant covered, as in hidden beneath your husband's identity. You are a femme covert, a covered woman. Your legal existence has been folded into his, like a letter sealed inside an envelope. The envelope can be opened, read, acted upon. But the letter itself? It has no agency, and it gets worse. That workshop your father gave you as part of your marriage portion, the one with looms and spinning wheels, the one you imagined running, employing women. Building something you can't legally operate it, not alone. You can't hire workers because you can't sign employment agreements. You can't rent the building because you can't enter binding contracts. If your husband is kind, he might act as your proxy, signing documents on your behalf, letting you work in his name. But if he's indifferent or cruel, or simply bad at business, there is nothing you can do. The workshop that was supposed to give you independence is just another asset on his balance sheet. Now imagine he drinks. Imagine he gambles your inheritance away, piece by piece, in alehouses and card games. Imagine he beats you, and you try to leave. The law has almost nothing for you. Divorce, as we understand it, does not exist. Legal separation is possible, but rare, expensive, and requires proof of extreme cruelty, and even if you get it, you don't get your property back. You don't get your legal identity back. You are still femme covert, just without a household. For most women's farmers, wives, servants, craftsmen's daughters, there was no escape. There was only hope. Hope that the man they married would be kind, competent, fair. Hope was not a strategy, but it was all the law allowed. If you were born female in Tudor England, your value was calculated early. Fathers kept ledgers. Daughters were listed alongside livestock and land. First daughter, 100 marks. Second daughter, 80 marks. Sheep, 200 head. Wool yield projected 40 pounds per annum. The math was cold and precise. Because England's inheritance laws favored primogeniture, everything to the eldest son daughters received dowries instead. A one-time payout. Their only inheritance. The moment they married, coverture made that dowry the husband's property. So a woman's entire economic value was transferred in a single ceremony, from her father's control to her husband's. Picture two fathers in a London townhouse, wine between them, parchment spread across the table. They're negotiating. My daughter brings 200 pounds in coin, plus linens valued at 20. She reads, writes, manages a household. 16 years old, excellent health, unblemished reputation. The other man nods. My son will provide a jointure 1/3 of the estate should he predecease her. She'll have a chamber in the manor house and an annual clothing allowance. I'll settle 20 pounds on her at the wedding. They are trading assets. The daughter in the next room embroiders. She knows this conversation is happening. She does not know what they're deciding. No one has asked her. When the deal is made, contracts are signed. Witnesses are called. The daughter's future, where she will live, who she will obey, what resources she will have access to, is locked in. She is 16. She has no legal power to object. And when things went wrong, when a father's business collapsed, when a ship sank or a partner defaulted, daughters became unmarketable, men who had been courting them vanished. Their dowries, promised but now unpayable, left them worthless in the marriage economy. They faced a life as dependents in their brothers' households, forever burdensome, forever unwanted. The most famous example of this involved a queen. Catherine of Aragon married Henry VIII's older brother Arthur in 1501. Spain paid an enormous dowry, 200,000 crowns, but Arthur died 5 months later. Spain wanted the dowry back. England refused. For 7 years, Catherine lived in limbo. Her dowry paid, but inaccessible. Her status unclear. Her future trapped between two kingdoms. She was a piece of disputed property. She survived on charity, wore the same gowns until they frayed, and had no legal power to resolve her own situation. Catherine's experience was royal in scale, but thousands of ordinary women faced the same trap. Their lives suspended, their value contested, their voices legally silent. Then came 1533. Henry VIII wanted a son. Catherine had given him only a daughter, Mary. Anne Boleyn promised him what Catherine could not. So Henry sought an annulment. The Pope refused. Henry's response was absolute. He rejected papal authority, declared himself supreme head of the Church of England, and broke with Rome entirely. Catherine's marriage was declared invalid. She was stripped of her title. She was no longer queen. She was Princess Dowager title from her first brief marriage to Arthur. She was forbidden from seeing her daughter. She was moved from estate to estate, each smaller and colder than the last. Her household was reduced. Her income slashed. She was isolated, surveilled, erased in slow motion. When she died in January 1536, Many whispered poison. The truth was darker. She had been legally murdered, piece by piece, while still alive. And every woman in England understood. Catherine of Aragon was the daughter of Ferdinand and Isabella II of the most powerful monarchs in Europe. She was educated, intelligent, politically skilled, beloved by the English people. She had served as regent, commanding the defense of England against a Scottish invasion. She had been a model queen for 24 years. None of it mattered. When Henry decided she was no longer useful, she became disposable. If a queen with royal blood and decades of service could be cast aside like that, what protection did anyone else have? The message rippled through every tavern, every manor house, every market square. Your position depends entirely on your husband's approval, and his approval depends on things you cannot control above all: your ability to produce male heirs. Let's be clear about the biology. A woman has a roughly 50% chance of conceiving a male child with each pregnancy. In Tudor England, 15 to 20% of male infants died before their first birthday. More died before adulthood. Producing even one surviving son was not guaranteed, but the pressure was immense. A wife who bore only daughters was considered a failure not by medicine, but by law, by family, by society. Then Henry did something that destroyed one of the few spaces where women had autonomy. Between 1536 and 1541, he dissolved the monasteries. His commissioners shut down every abbey, priory, and convent in England. For monks, this was disruptive but manageable. Most were educated men. They became parish priests, tutors, administrators. They received pensions and could marry under the new religious order. For nuns, it was catastrophic. A nun was not subject to coverture because she was not married. She answered to her abbess, her order, and God, not to a father or husband. Convents were places where women could live with genuine autonomy. They could be educated, they could own property, they could hold authority. For women who didn't want marriage or who sought intellectual or spiritual life, the convent was refuge. Consider Alice Montague, Abbess of Barking. She presided over one of the wealthiest religious houses in England, managing vast estates, employing hundreds, wielding real power. When the commissioners came in 1539, she was forced to surrender everything. Her pension, £133 a year, sounded generous. Until you realize she had been managing an institution worth over £1,000 annually. What was Alice supposed to do? She couldn't marry. She had taken solemn vows. She had no family estate. She had spent her entire adult life in religious service. Her pension left her in limbo, too wealthy for labor, too poor for independence. With no clear role in a society that had no place for unmarried women with authority, multiply Alice's story by thousands. Young nuns, elderly nuns, women who had entered religious life as children, all displaced into a world that didn't want them. The pensions they received were smaller than those given to monks. Some ended up destitute. Some sent desperate petitions to the crown, begging for help that rarely came. And the fear didn't stop at the convent gates. Henry's Treason Act of 1534 made it a capital crime to deny the king's supremacy over the church. But the law was written broadly. It criminalized words, not just deeds. In kitchens, in bedchambers, in sewing circles, private conversations became dangerous. A woman who expressed sympathy for Catherine, who refused to acknowledge Anne Boleyn as queen, who questioned Henry's religious changes, any of them could be accused. Margaret Pole, Countess of Salisbury, was executed in 1541. She was 67 years old. Her crime: suspected sympathy for the old queen and her family's royal blood. Elizabeth Barton, a nun known as the Holy Maid of Kent, was executed in 1534 for prophesying against the king's remarriage. And Askew was tortured on the rack and burned at the stake in 1546 for her Protestant beliefs. For ordinary women, the terror was quieter, but just as real. A refusal to swear the oath of supremacy could cost you your home. A husband accused of treason could leave his wife and children penniless with no legal recourse. Yet there was one strange, dark path to personhood: widowhood. When a husband died, coverture lifted. A widow became a femme solo woman alone. She could own property, sign contracts, sue, and be sued. She could hire workers, run businesses, make binding decisions. For many women, this was the first time since childhood they had been legally visible. Common law gave widows dower rights, typically a life interest in 1/3 of the husband's estate. If he'd been a craftsman, she might inherit his tools, his shop, his reputation. Court records from Tudor England are full of widows. Widows suing for unpaid debts. Widows running taverns. Widows managing breweries and textile workshops. They appear in the legal record far more than married women, might be because there were more of them, but because they were the only women with standing to act. Take Joan Dance, a brewer's widow in 1530s London. When her husband died, she inherited his brewery. Within 5 years, she had expanded the business, bought 2 more properties, and become one of the largest beer suppliers in her ward. She hired workers. She sued debtors. She negotiated contracts. All things she legally could not have done while married. But freedom was fragile. If a widow remarried, coverture returned. Everything she'd built, the business, the property, the independence, would fall under her new husband's control. The moment she said, "I do" again, she ceased to exist. So widows faced an impossible choice: companionship or autonomy, security or freedom. For men, marriage offered both. For women, the two were mutually exclusive, and not all widows had options. Poor widows, elderly widows, widows without valuable skills, they appear in parish records as recipients of relief. Small payments to keep them from starvation. Their survival depended on charity, on the goodwill of neighbors and church wardens who had no legal obligation to help. The law was absolute, but the reality of daily life was more complex. Many marriages functioned as partnerships. A merchant's wife ran the shop while he traveled. A farmer's wife managed brewing, dairy production, textile work labor that generated real income. These women weren't legally empowered, but families often couldn't survive without them. Some women pushed back. Anne Boleyn herself was known for arguing theology with Henry, for interfering in politics, for refusing to play the silent wife. Her boldness scandalized the court. It also made her vulnerable. When Henry turned against her, her shrewish behavior was cited as evidence she was unsuitable. She was executed on May 19, 1536, officially for adultery and treason, but really for speaking too freely and failing to produce a son. For most women, resistance was quieter. A wife might hide money from a spendthrift husband. A woman running a small trade might underreport her earnings. Were these acts theft? Under coverture, technically a wife couldn't steal from her husband, because she couldn't own property in the first place. But morally, these women were reclaiming fragments of autonomy in a system designed to deny them any. Some avoided coverture entirely by refusing marriage. Wealthy women who inherited estates sometimes stayed single to maintain control. Elizabeth I is the most famous example. She declared herself married to England and refused every suitor. This wasn't just symbolism. Elizabeth knew that marriage would destroy her power. Under coverture, her husband would control her person, her throne, her kingdom. She couldn't risk it. Coverture didn't end with the Tudors. It didn't end with the Stuarts or the Georgians or even the Victorians. The legal doctrine that erased married women persisted in English law until the Married Women's Property Acts of the late 19th century, more than 300 years after Henry VIII's death. The first major reform, in 1870, allowed women to keep their own wages. Full property rights didn't arrive until 1882. Think about that. The system that turned marriage into ownership lasted longer than the United States has existed as a nation. Women born in Tudor England, raised under coverture, married under coverture, died under coverture, and So did their daughters and granddaughters and great-great-granddaughters. Coverture wasn't just a legal technicality. It was the formal expression of an ideology that women were not fully human in the way men were, that they required guardianship, that their voices, their labor, their very selves could be absorbed into another person's legal identity without moral consequence. This ideology shaped everything. It justified excluding women from universities, from professions, from political life. If a woman couldn't sign a contract, how could she be a lawyer? If she couldn't own property, how could she run a business? If her legal existence was subsumed by marriage, how could she vote or hold office? The legal erasure enabled the social erasure. Women's experiences were deemed unimportant, their suffering invisible. When historians later told the story of Tudor England, they told the stories of kings and wars and parliaments, all male domains. The quiet, systemic oppression of women barely registered. History recalls Henry VIII for 2 executions. The real toll was quieter. Under coverture, thousands of women lost legal existence, builders, widows, mothers erased by law, not blades. Their names vanished, but they endured, leaving petitions, wills, and accounts behind. Coverture ended, their stories were buried. They deserve remembrance, not as symbols, but as lives lived.